Hello, my name's Julie Williams and I'm from Migration Down Under, and I'm going to talk to you today about partner visas. Partner visas. Often I get questioned, what is the difference between partners and spouses? Well, really there is nothing. A partner is the more, modern terminology or politically correct terminology for a spouse. And a partner or a spouse can be a married spouse, can be de facto, can be same-sex partner. They're all treated exactly the same as the Department of Immigration. You've all got to show the same level of committed relationship. There are offshore, onshore applications. There's the offshore 309 and the equivalent is the onshore 820 that then leads into permanent residency. And then there's the prospective marriage visa or the fiancé visa, the 300 subclass. Now, what I'm going to talk to you today about is more so the changes and that may be occurring in the future, as well as what's mostly on the important question on everyone's mind at the moment is the length of processing that it's taking, because it certainly is taking a lot longer than we are used to, and especially for those that can't be together or in different places or different countries at the moment. I've got some good news though in regards to the offshore, and that I'll go into that further. Now, in regards to the processing, I mean, I've been around so long, I can remember when you could go up to the Department of Immigration with your application and have it approved in the same day. Unfortunately, those good old days have gone, and we're now experiencing at least a 12 to 18 month processing for onshore applications, and that's what's indicated on the Department of Immigration's website, and that's what we're not necessarily experiencing. We're experiencing a lot quicker processing, and but on average you can expect at least 12 months for the onshore applications. Now, the processing, why is it taking so long? It's the sheer volume of applications that are being lodged and perhaps the lack of resources that the Department of Immigration have. Unfortunately, it's not their fault. It's the Australian government and the way they divvy up the budget each year. And they have reduced the number of staff and they have reduced the number of resources. So with the onshore partner processing, you're looking at an average about 100 case officers Australia-wide working on, at the moment, there is 35,000 applications, onshore applications in the pipeline. That's not considering the offshore applications, that's only onshore. 35,000 divided amongst 100 people, that is a lot of applications to have to get through, and especially when not all staff are full-timers. Some of them are part-time, some of them are casual, and inevitably they all take holidays just like you and I, so that's why the slower processing. The average applications that they process a year is 24,000 onshore. In the budget they allow for at least 50,000 applications to be processed in one financial year, although there is no official cap, and on average they have been dealing with 24,000 per year. Now, with the onshore applications, I guess the beauty is if you can lodge an onshore application, you do get a bridging visa, and you are then given permission to work when you are on that bridging visa A. And so I guess the impact of the processing time doesn't impact as greatly as those that are offshore. The other advantage with the onshore application is whilst it may take 12 to 18 months for the provisional visa, remember you're applying for permanent residency, and permanent residency is considered from 2 years from when you initially lodge it. So if you've lodged your 820, 801 application and you're not eligible for permanent residency straight away, then you'll be granted a provisional visa, and then if it does take 18 months, then you're only having to wait another 6 months before you're eligible for permanent residency. But unfortunately, there is a downside with the permanent residency processing, because that too is taking a long time. That's taking about 8 to 12 months. So from when you initially lodge a partner visa for an 820 and your relationship's less than 3 years, you can look at least a 3-year wait until you get your full permanent residency. The good news is for offshore applications that it's a lot quicker. So I do encourage you, if you do have the opportunity, or if you aren't in a rush to arrive in Australia to be reunited with your partner, then an offshore application can be a good option for you because they don't have the volume and the applications are dispersed amongst the different processing offices depending which country you're from and where you are at the time of lodgement. So you may find that lodging an offshore application will be granted a lot sooner. We've got experience from that, and we're been lucky to get offshore applications approved within sort of 6 months. So a huge difference from the 12 months of onshore applications. The other advantage to doing the offshore application, I shouldn't say the offshore application. The other advantage of doing a decision ready application, which at Migration Down Under we like to do, if you have got all your documentation and you've got a strong supporting evidence of your relationship, you'll find that your application may get approved a lot sooner than the published processing times. And that's what we are finding, because whilst they've always traditionally processed applications in chronological order, applications lodged prior to January this year, that they're all trying to assess and look at fast tracking and getting approved by the end of June 2017. And we've actually noticed that and have had experience. Just recently we got an application approved yesterday towards the end of May, and that was lodged at the end of September. So you can see that that was a pretty quick turnaround for an onshore 820 application. Now, changes that have occurred or are occurring that you may or may not be aware of. Part of the government's commitment to addressing family violence, they have introduced from November 2016 for all sponsors to now undergo a character test. So all sponsors, as well as the applicants, now have to obtain a police clearance for Australia and for any country they've lived in for 12 months or more in the last 10 years. What they're looking at doing is making certain that they're looking at changing the way applications are lodged and processed, in the fact that you will have to lodge and have a sponsorship approved prior to the visa application, which is in reverse of what is happening at the moment. At the moment you lodge your visa application and then you're prompted to lodge the sponsorship application. But at the moment there's no impediment to be able to lodge the sponsor application with the visa because there has been no changes. Nothing has been passed through Parliament, and there's been no legislation changes as to how the processing of the 820, 309 or the 300 work. So at the moment you're still lodging the visa application followed by the sponsorship. However, from all applications lodged from November 2016, just be aware the sponsor will need to undergo character checks. They're also looking at the validity of the 820. At the moment, when you're granted an 820 visa, the visa is valid indefinitely until a decision is made on your 801. And the 801 is granted once you can show that you are still in a genuine spouse relationship at the time they're looking at processing and granting your permanent residency. So the 820 at the moment is indefinite, but they're looking at implementing a validity date on the 820 to be 3 years from the date of grant, so that then that prompts you to have to lodge the 801. Up until recently, very recently, with the 801, all applicants have been reminded or been invited to apply for their their permanent residency 801 by the Department of Immigration. They've been sending out an email about 6 weeks prior to your eligibility, and due to the lack of resources and the blowout of processing times, they've actually discontinued this. and that ceased at the beginning of May. So you won't be getting those traditional prompts to lodge the 801 anymore. If you've come through us, Migration Down Under, well, we'll obviously advise when you're eligible. Otherwise, if you've lodged the application yourself, just be aware when your 2-year eligibility date is to apply for permanent residency, so that you don't miss that, because the department are no longer going to be contacting you to prompt you to do that. But that's about all the changes that we're aware of that are going to be occurring over possibly the next 12 months. It's all a matter of timing, and when the government has time to sit down and address all these new legislation proposals through Parliament. But if there's any questions at all, you know where you should come to us at Migration Down Under, as we'll be able to answer all your questions and concerns that you may have for your partner visa. You can contact us on 02 9419 5411 or send us an email, info@migrationdownunder.com. We look forward to working with you.